If you file a lawsuit and it's in court, it's going to be a public document. Anybody can find it. A new prospective employer can find it, and that can be a reason. And they're probably not going to tell you that. They're probably going to say, well, we found this lawsuit, so we're not going to hire you. They just don't schedule the interview. When it comes to employment law, no question is too small. Today we're answering more of your important questions right from the comments section. Would you recommend telling HR you are recording in hopes that they are honest about your termination? I will be asking for a letter of termination because it sounds like they are saying I left, putting this in quotes, so abandoning the job site, I guess. That's a tough one. In some states, you might be required by law to tell the other person that you're recording the call. States tend to either be what we call one-party or two-party states. In one-party states like Virginia, you don't have to tell anybody you're recording. As long as it's you as part of the conversation, and obviously you know you're recording, you're not required to by law. If your state is a two-party state, for example, like Maryland, then you have to inform the other party, if you're in Maryland and you're recording, that they are being recording. So you want to consider that first. Is it going to make them be more honest? It's probably going to make them be more guarded. I think HR these days, well, good ones anyway, are probably assuming or acting as if they are being recorded. They may record now with all the different recording devices, and particularly if it's done on Zoom or some kind of remote platform, it's easy to record them. They may be recording it. So I don't know that it offers you a big advantage. If you're going to record it, it doesn't hurt to tell them. I mean, they would have the right to ask you not to record it. So it's a tough call. I don't know that as a practical matter it's going to affect what they say. You can certainly ask for a letter of termination. They may or may not give you one. They're not required to, but they may give you a letter of termination, and they may give the reason for it, because here, if they're saying that you left the job, that's probably what they're going to put in the termination letter. Of course, if that's not true, then you'll have a chance to prove that later, particularly if you file for unemployment insurance benefits. We see this all the time, where the employer will try to deny you the benefits by coming up with some reason that's untrue to make you ineligible, and then you can prove, for example, like that you gave notice or that you were there on the job that day or whatever it may be. Similarly, if you have a discrimination case or some other kind of workplace case, then you'll be able to offer evidence that you did not, in fact, leave the job. With damage caps included, can you still sue for multiple things: harassment, discrimination, intimidation, retaliation, to make your case worth more? This is also a very good question. So generally, it doesn't matter how many claims you put in there, particularly if we're talking under Title VII, which is the big anti-discrimination law. In most state laws, you only have to hit on one of them, right? So if you hit on the discrimination, if you hit on the retaliation, if you hit on the harassment, you hit on all three. You don't get to triplet if you hit on all three. That just means your employer is liable. So it's almost like, if you shoot a gun at a glass bottle. If you hit it with one bullet, it's going to shatter. Doesn't matter if you fire one bullet or 10. If that first bullet it's going to shatter. And the same way in employment lawsuits, if you win on that, you get that first claim, you move to the damages category. But it doesn't matter if you hit on one claim or three claims. Now, there are some exceptions to this. If you are filing claims under Title VII and filing some claims under state law, and there are no caps, those claims have different value. The ones under Title VII are going to be subject to caps. The ones under the state law may not be subject to caps. And so if you hit one under the federal law and one under state, then that can make it more valuable. And that's really worth, it's where an attorney can really earn his or her keep by helping you navigate this. There are some federal claims where this might apply. There's something called a Section 1981 claim that applies to race and national origin discriminations. Under Section 1981, there are no caps. So if you file under Title VII and under 1981, if you hit under 1981, that's going to be much more valuable than if you hit under Title VII. And you can file them both, right? The same discrimination claim can be a Title VII claim and can be Section 1981. So as a practical matter, if you win on one, you're probably going to win on both. So in those situations, it can affect the damages calculation. So great question. Again, worth talking to an attorney, even just to get a consult to see, are there different pots of value for you depending on how you frame your case. What if a lawsuit you filed against a former employer for discrimination and wrongful termination is the thing that's sabotaging your job search? I know it probably isn't the easiest thing to prove, but if you have a suspicion that your applications are being overlooked due to your lawsuit being made public and can easily be found by Googling your name, can you use this to justify why you've been having difficulty finding new employment after over years of searching? This happens a lot, unfortunately. So sure, it's entirely possible that, if you file a lawsuit and it's in court, it's going to be a public document. Anybody can find it. A new prospective employer can find it, and that can be a reason. And they're probably not going to tell you that. They're probably going to say, well, we found this lawsuit, so we're not going to hire you. They just don't schedule the interview, or they don't give you the job offer. And I think if you are engaged, and the issue here is, you've got to show what we call mitigation. So in litigation against your former employer, if you've been fired, you've got to show that you're making efforts to find a new job. I think it's entirely common sense that if you have filed publicly against them, that can make it difficult for you to find a job. You can get expert testimony to that effect. There are people who do this sort of thing who can provide testimony that, it could be a reason that you're not getting a job. I'm sorry that happens. It's happening to you. I would say another thing is to perhaps get a professional to help you with your job search if you haven't done that already. Many of them are used to dealing with this and can help give you kind of tips and tricks and way to work your way around it. But absolutely, it can be a reason that you might be having trouble finding another job. Have you ever dealt with loss of jurisdiction? Is the next step getting revoked or denied security clearance? Not entirely clear on the connection between the two. There certainly are jurisdictional principles that apply in employment law. For example, like the EEOC that we've been talking about has jurisdiction over some claims and not over others. So the EEOC would not consider a breach of contract claim. EEOC is not going to consider a wage claim because those are outside of its jurisdiction. Same way with some courts, there can be matters outside of their jurisdiction that they just by law cannot hear. Most courts are, if you're looking at trial courts at the state or federal level, can hear most cases. You might have there's some unusual ones, like if you're dealing with an intellectual property matter, like you might have to bring that in federal court rather than state court. A state court would not have jurisdiction. So yes, it's possible to have a loss of jurisdiction, in which case you would just go to the correct venue, the correct court. It's rare that you have loss of jurisdiction because you just completely don't have a place to have your claim heard. Is the next step getting revoked or denied security clearance? The security clearance process is entirely separate. But it can overlap with underlying investigations, workplace investigations. So you could be part of a discrimination or harassment case, and there's a parallel security clearance case going on. So if you've got a security clearance matter, then those courts have jurisdiction over that, and you should be able to litigate those issues in the cases that hear the courts that hear security clearance issues. So, a good question. I hope that helped. We appreciate all your great questions. Keep them coming in the comments, and we'll be sure to have more answers just for you.